Thank you all for attending our first GHY University webinar of 2016. Firms who trade globally need to be aware of free trade agreements and the rules required to allow their products to enter those countries utilizing their lower rates of duty. This course will provide an overview to the current and emerging global free trade agreements with case studies and examples of utilization covering the risks, benefits, and opportunities. After the presentation, we will be sending out the copy of the presentation slide deck, the recording of this webinar, along with a survey to help us better your GHY University experience for future webinars. If you wish to post on social media about this presentation, please do, but we kindly ask that you use the hashtag GHYU. And so a few housekeeping rules before we begin. This event will be recorded, and both the recording and the presentation slide deck will be made available after the webinar. You will all be in listen-only mode for the webinar. If you have any questions, please use Ask the Question function on your GoToWebinars panel. All questions will be addressed at the end of the presentation unless there is a common recurring question. If you are experiencing technical difficulties, please use the chat function on your GoToWebinars panel or email myself, Maria, directly at maria@ghy.com. And so a little bit about us before we begin. GHY manages more than $5 billion of cross-border trade annually through our Canadian and U.S. brokerage operations. We pay more than $100 million annually to governments on behalf of our clients, and we work with more than 1,000 importers and exporters. Growth and continuity through 4 successive generations is an incredible milestone. GHY has achieved it thanks to the dedicated people delivering quality service to great customers. It is a testament to the power of the highest levels of commitment, professionalism, and integrity. Our clients' needs shape our endeavors. We strive to understand our clients and share our collective knowledge to help them succeed at global trade. We are committed to going the extra mile to provide the best service and trade solutions possible. To do so, we invest time and resources into training and equipping our associates with the technology and tools they need to excel. Today's GHY webinar will be presented by our Vice President of Consulting, Bob Cowie. Bob is a certified customs specialist and is one of GHY's longest-serving associates, having started with the company in 1972. He's worked in various operational roles and was mentored by the previous generations of leaders to become the most accomplished experts in the garment and textile industry in Canada. He has extensive knowledge of customs regulations and works with both our Canadian and U.S. account managers and GHY's clients on complex regulatory challenges. Bob is well known in the Manitoba region for his skill, energy, enthusiasm, and commitment to solving problems with creative and effective solutions for clients. He is a member of the Canadian Apparel Federation and works with Canadian and U.S. operations to provide value-added solutions to clients who are shaping their trade-related programs. And so without further ado, allow me to pass it over to Bob.
Thank you, Maria. And hello, everyone. So this morning we're going to be talking about free trade agreements. The governments of Canada and the United States are committed to creating new opportunities and favorable conditions for businesses to compete internationally. Canada currently has free trade agreements in force with more than 15 countries, and the United States currently have 14 free trade agreements in force. These agreements enable both Canada and the US to compete on a more even playing field with local firms in the free trade agreement partner country. They allow for a reduction or elimination of duties. Some are immediate, as was the case with the United States-Israeli Free Trade Agreement or the Canada-Jordan Free Trade Agreement, while others are over a period of time, such as the NAFTA Free Trade Agreement and the Canada-Korea Free Trade Agreement. I'd like to tell you a story about the Canada-European Free Trade Association Agreement that came into force on July 1st, 2009. Now, the EFTA, as it's called, is made up of Liechtenstein, Iceland, Norway, and Switzerland, not to be confused with the Canada-European Union Agreement, which many Canadians are referring to as the Wayne Gretzky of trade deals. More to come on that later. Anyhow, one of our clients was importing a beverage that was manufactured in Austria and carried a duty rate of 12.5% when imported into Canada. They were aware of the fact that the product was produced in more than one country and discovered that the product was also manufactured in Switzerland. Moving the production to Switzerland realized savings of $8 million in duty on an annual basis. Another important factor in negotiations for free trade agreements involve a reduction or elimination of quotas. I'm sure most of you have been reading about the pending Canada-European Union Free Trade Agreement and the EU firm's insistence on either eliminating or increasing the quota levels for the entrance of dairy products into Canada, with cheese imports being one of the bigger topics. Imports of dairy products into Canada are subject to import controls referred to as tariff rate quotas. Currently, the tariff rate quota for cheese products into Canada is limited to just over 20.4 kilograms per year, and it's allocated to traditional import allocation holders on the basis of their historical imports. So if you're not a current quota holder, it is highly unlikely you will be able to receive any allocation. Outside of these limits, and unless you are a current quota holder, duties are 245.5%. So the European cheesemakers are asking for increases to double the current access, and our Canadian government is considering compensation to Canadian dairy farmers if they lose money because of the agreement. On a side note, in February of this year, February 29th to be exact, Canada's Minister of International Trade, Krista Freeland, and the European Union's Commissioner for Trade, Cecilia Malmström, announced that the completion of the legal review of the agreement. The agreement is currently undergoing translation into France and the other 21 EU treaty languages. Following this transition, the process to approve the agreement will begin. So we're probably most likely looking at no earlier than 2017 for this to take effect. So the next slide you're looking at here shows the current free trade agreements that Canada have in effect and the dates they came into effect. Included is the link to the Customs D Memorandum publications that provide details on the rules of origin to determine the originating status of a good and the product-specific rules of origin that establish the point at which materials or components have undergone sufficient production within the free trade area agreement for the good to be considered originating. So I encourage you all to write this memo down, and if you're trading in any of these countries, you should really have a look at the memorandum. It has got all kinds of good things, including marking regulations and all that type of stuff. It's hard to believe that it's been 27 years since Canada signed its first free trade agreement with the United States. Qualifying products have been duty-free since January 1st, 1998. This does not mean that firms do not need to verify the originating status on a yearly basis. Many of the NAFTA rules have a regional value content provision, 50% under the net cost method or 60% under the regional or under the transaction value method. With many of the manufacturing inputs coming from countries outside of the NAFTA territory, we have experienced an increase in both US and Canada audits with regards to NAFTA certification. Technology has not only allowed importers and exporters to do business more effectively globally, but has also enabled both the Canada Border Service Agencies and the United States Customs Border Protection to target more effectively in areas of non-compliance. We recently had a situation with a Canadian company that received a verification audit for 3 transactions that they had with one particular vendor, and found that the goods being claimed under NAFTA did not meet the applicable rule of origin due to sourcing changes over the last few years on their manufacturing inputs. Canada Border Services agencies were able to determine from their systems to what companies were importing from this particular vendor and target in on those transactions specifically. Be aware that in these types of situations, it is you as the importer who would be subject to any additional duties and possible penalties. Also of note is that some of Canada's free trade agreements, such as those with the US, Mexico, Chile, Costa Rica, and Honduras, contain tariff preference level provisions for certain textile and apparel goods being imported or exported within the respective free trade zones. Tariff preference eligible goods are goods that do not meet the requirements of the free trade agreement rules of origin, but can still receive the same preferential tariff treatment as originating goods up to a negotiated quantity, as long as these meet certain conditions, such as being cut, sewn, and assembled in a party from non-originating material. Outside of these negotiated levels does not mean you cannot import the goods. It just means that you pay duty under the most favored rate of duty, as if you're importing from a non-free trade agreement partner. What is also interesting is an article that I actually just read yesterday from the Canadian Apparel Federation, indicating that the Canadian government is looking for comments on a proposal to modify the Canada-Colombia Free Trade Agreement relating to apparel. Colombia has asked for changes to the short supply provisions in the agreement. Under these provisions, certain textile products are considered to be unavailable in either Canada or Colombia, and as a result, apparel made in either Colombia or Canada from those textiles will still qualify for free trade, no matter where the textiles are sourced. The general rule of origin currently for apparel requires that the fabric and yarn must be sourced from either Canada or Colombia to qualify for free trade. So what this tells you in looking at this slide is that even though we have agreements in place, there's always the ability in most cases to have our governments kind of retool them a little bit to keep up with modern times. The next slide shows the free trade agreements that have recently been concluded. Both the US and Canada are part of the Trans-Pacific Partnership Agreement. The TPP agreement, as it's the acronym is for the Trans-Pacific Partnership, was signed on October 1st, 2015, but neither Canada or the US have yet ratified the agreement. This is an interesting free trade agreement and includes the USA, Canada, Japan, Malaysia, Vietnam, Singapore, Brunei, Australia, New Zealand, Mexico, Chile, and Peru. These countries comprise almost 40% of gross domestic product globally. And the interesting thing about this agreement is with the US and Canada as the first and second largest economies, they both need to have this agreement signed to meet the 85% requirement for the whole agreement to take place. If either one of those countries refuse to ratify, the TPP cannot come into force. The TPP includes schedules for duty and fee elimination. Much like you may be aware of the fact that the US government currently have customs user fees, commonly referred to as merchandise processing fees, on goods that are non-NAFTA. So if you're importing something from a country other than Canada or the United States, you pay that merchandise processing fee. Some of the free trade agreements that they're negotiating now are going to include an elimination of these fees, while others aren't. So it's interesting to be aware of the fact that when these agreements are signed, you need to be aware of all the rules, and there are little nuances that are amongst the agreements as we sign all these things. These schedules are specific to countries, and within those national schedules, specific products. Some duties will be eliminated immediately, while others transitioned over a period of time, ranging from a few short years to well over 20. I'll give you an example of the Trans-Pacific Partnership Agreement. US cars being imported into Malaysia and Vietnam are scheduled to have the duty eliminated over a 4-year period. On the other hand, trucks imported into the US from Japan, which currently have a 25% duty rate, are going to carry a 25-year period for duty-free status, giving the United States car or truck makers time to be able to catch up to all of the new requirements. Footwear imports into Canada, which currently have duty rates as high as 18%, are scheduled to be duty-free once, or should I say if, the agreement comes into force. So we've already had some calls from some of our clients who have suppliers in China who have factories in Vietnam. Vietnam is part of the Trans-Pacific Partnership. So if a company in China has a factory in Vietnam, and you can move that production over to Vietnam, there's a good chance that you can import the product free. Footwear being a prime example where you're looking at an 18% duty rate in Canada. And I'm sure the same situation will happen in the United States if this gets ratified as well, because China is not a part of any of the current free trade agreements we have in place. We had earlier touched base on some of the points of contention under the Canada-European Trade Associates Agreement. That's that Norway-Liechtenstein example I gave you on the beverages. So these next couple of slides show some of the ongoing free trade agreements that Canada is currently considering. We've got the Canada-Caribbean Community, referred to as the CARICOM. The Canada, Guatemala, Nicaragua, El Salvador, Dominican Republic, India, Japan, Morocco, Singapore. They're talking about modernizing or changing the rules of the Canada-Costa Rica Free Trade Agreement. A lot of that, again, goes to some of the fabrics that aren't being able to be sourced in Canada or Costa Rica. These, they call them short supply fabrics. So regardless whether or not a garment may be made out of those fabrics that aren't sourced within the territories, it would still qualify. The thing that really is interesting here is I look at this, so let's assume that the agreement doesn't take place, the Trans-Pacific Partnership. Well, Canada are already in conversations with Japan and Singapore, which are part of the TPP. So if you've got goods imported from Japan and the TPP falls through, there still may be a free trade agreement between Canada and Japan. And these are some of the exploratory discussions. Marie and I were just looking when we were I had made a mistake in spelling Mercosur. So we're still trying to find out where that country is. So that's an interesting one. So if you guys want to comment on that, maybe in some of your chat stuff, we'll both learn, or we'll all learn something. And then there's Canada, Turkey, Canada, Philippines, Canada, Taiwan. So those are just some of the ongoing or the exploratory discussions that we have. So this next slide is an interesting slide because it shows the free trade agreements that the US currently have, as well as a link to the US website that provides information with regards to those agreements. Over the last decade, the number of free trade agreements and trade legislation programs has increased significantly. And in response to this current trade environment reality, Customs Border Protection has designated trade agreements as a priority trade issue. What that means is that companies are being audited. If you're importing or exporting these materials, there are the rules, and they're just making sure that the rules are followed. These trade priorities are limited to goods other than textile and apparel. Because they are handled, they have a separate agreement for textiles. It's a separate trade priority issue. So in the U.S., they have some different there's trade priorities for goods, and there's trade priorities for textiles and apparel separately. Just a couple of little tidbits I want to have you look. If you look at this one here, you'll notice I didn't put any effective dates in there. And I just want to read a couple of stats to show you how important free trade agreements can be. Australia, for instance. So US has a free trade agreement with Australia. It concluded in February of 2004. And it went into force on January 1st, 2005. So it stimulated a 104% increase in the US trade surplus with Australia. In 2013, the United States exported $26.1 billion in goods from Australia, and they imported $9.2 billion. You go to some of these other free trade agreements, for instance, the one that I kind of find real interesting is the one that is the Canada-US or the Canada-Israeli free trade agreement. It was the US's first free trade agreement that they signed. It went into force on September the 1st, 1995. And in 2013, the United States exported $13.7 billion in goods to Israel and imported 22.8 billion in goods from Israel. So just a lot of little tidbits as to how important, if you're trading with these countries, it seems to really make a difference in the overall dollars when an agreement is signed. This next slide is an interesting, and it provides a link to the U.S. Customs Border Protection website, providing a side-by-side comparison of the free trade agreements and selected preferential trade legislation for lawn textiles. This link to the website, the free trade agreements, it refers to the customs memorandums, to the U.S. website laws, which are equivalent to our Canadian memorandums. So if you click on that, it'll tell you what the U.S. law regulation is, the tariff phase-out rates, and all kinds of interesting information on that one. They caution all, sorry about that, I just lost my train of thought here for a second. They caution all to know your responsibility before making a free trade claim with respect to reasonable care, record keeping, and customs value. The textile sector is one of the largest manufacturing employers in the United States, and therefore placing textiles and apparel as a separate trade priority. In Canada, the duty rate on garments, for instance, is generally either 17 or 18%. And although the average duty rate for apparel imports into the US is 16%, there are some huge discrepancies on certain products. I'll just give you an example of a woven down-filled nylon jacket. Well, there are down requirements, but if it's a down-filled nylon jacket, it can have a duty rate of 4.4%. Whereas if it's just a regular fiber filled jacket, the duty rate goes as high as 27.7%. I just want to read these last bullet points, the last 3 bullet points that are on the slide here. 40% of the duties collected by the United States Customs Border Protection in the fiscal year 2014 were related to textile imports. The average duty rate of 16%, and more than $21.1 billion of entered textiles and wearing apparel claim preferential tariff treatment. It's a high risk for non-compliance, therefore it's a Customs Border Protection trade priority. This last slide here has got a link to an application for an advance ruling in respect to goods to be imported from a free trade partner. And you can apply for a ruling to deal with issues such as origin, marking, etc. And it can be made by importers, customs brokers, as well as exporters and producers of those goods in a free trade partner other than Canada. Sourcing changes can affect whether your products qualify for preferential treatment, and one must carefully review any anticipated changes to ensure your product is not affected by the specific rule of origin for your product. Most free trade agreements have a direct shipment requirement where the goods cannot enter the commerce of another country in order to qualify for preferential duty rates. In Canada, for instance, other than a minor processing requirement under the Canada-Israeli Free Trade Agreement for goods shipped out of the US, they must be shipped direct from that country. That goes for most of the free trade agreements in the United States as well. This becomes really important when you're shipping goods to multiple countries with considerations regarding duty drawback, first sale concepts, and other trade-related programs within those countries. Both Canada and the US have a free trade agreement with Jordan, for instance, and products are duty-free provided they are shipped directly to either Canada or the US from Jordan. we had a situation where a company imported garments directly into Canada from Jordan. They entered the commerce of Canada duty-free and just assumed that they would also be duty-free into the United States, since the United States had a free trade agreement with them. Well, it turned out there is a direct shipment requirement, and the fact that they had entered the commerce of Canada and were shipped from Canada to the US meant they were subject to duty, 28.2% into the US. And since they entered the commerce of Canada, the duty was assessed on their selling price opposed to their imported cost, which would have been available under one of the first sale scenarios. So we already provided a good example with regards to the beverages imported from the Switzerland plant opposed to Austria. So now we're going to talk about an example that I'm going to give you about a bad example. So we had a situation where we had a Canadian company that was purchasing garments from a US company. The US company provided a NAFTA certificate saying, we make the stuff and the stuff qualifies. Customs did a review of that exporter and asked for documentation as to where they got their fabric and all that other type of stuff. It turns out that during the particular year that they were auditing, I think it was 2013, halfway through the year, their vendor decided to source their fabric from non-NAFTA countries to save dollars, and didn't let the people that signed the NAFTA certificate know this. So they had our client had a NAFTA certificate saying the goods qualified. Turns out that when the people in purchasing sourced their fabric, they didn't communicate it to the people that issued the NAFTA certificate. They found out that the goods didn't qualify. I think I had earlier explained to you that under the Canada-NAFTA agreement, they have what's called a tariff preference levels. So in other words, even though you may be importing something from the United States and it's non-NAFTA fabric, you can still probably qualify for duty-free status up to certain levels. And usually those levels for these types of situations, they become exhausted in April. So you can bring all your stuff in duty-free, say till May the 1st, and then after that, you're bringing them into Canada, but you're paying duty. But in the particular case here, they can't get retroactive tariff preference levels, so they went back and had to pay duty for all of the entries that they sent to Canada when they changed their fabric sourcing. And now they're having to go back and find out, do we have any ghosts or what has happened in 2014, 15, and currently. So that's kind of one of the bad examples as to what can happen if you're not communicating properly with your vendors. And everyone likes horror stories, as I've always said, as long as they're not your own. This is a real ugly situation. A particular Canadian company were purchasing corn dogs. Some of you may have heard this before, but if you haven't, it's a good story. I love to tell it. They were importing corn dogs from the United States. They'd been importing them for years. They only brought in two products, corn dogs and pizza. The vendor, their supplier, had issued the NAFTA certificate saying that the goods were made in the US. The tariff classification they were using indicated that they were predominantly made of pork, and there are no quotas on pork, so they were duty-free. Customs did an audit, and rumor has it might have been a Canadian customs official that was buying corn dogs in their local store and noticed on the label, and if you're familiar with some of the food products and the labeling requirements, they list the ingredients by greatest percentage first. And it indicated on these particular ones that they were buying that it was chicken. So as you are all aware, we all want to eat more healthy. So most people, healthy people, are buying a lot of boneless chicken. So there's a lot of these carcasses that are left over that people are using to ground up and make things like your chicken nuggets, and you've all heard those stories. So it turns out that this particular supplier were making their corn dogs with chicken opposed to pork. Chicken, unfortunately, is a quota item in Canada. It's much like the cheese we talked about earlier. So you need to have quota to bring in chicken. Obviously, this client wasn't a manufacturer. They couldn't get any quota. There are some exemptions for things like spent fowl, but spent fowl are old hens, and apparently I've heard it's used to make things like soup and some of those cheaper chicken pot pies you can buy in the stores. But the long and short of it is they couldn't get any quota. You know, they hopefully are going to be able to recover the money from their supplier who had given them, I guess, a false NAFTA certificate. But the end result being $3 million in duty for the year they were looking at, and this company is no longer in business. So that's kind of one of the horror stories. And I think I've given you a good, a bad, and an ugly. I'm going to ask now, Maria, what kind of time are we at here? Getting close to our hour?
Yeah, it looks like we're doing good. We're almost at a half hour. And so we've got a little bit of time left here. If anybody has any questions, we've got a few minutes. I'm just manning the question line here. So you're more than free to ask whatever you're wondering. We'll just give it a minute or two. Okay, we've got a question from Bree Beber. It is, how can we ensure our purchasing team advises us of scoring changes?
Is that sourcing changes?
Sourcing changes. How can we ensure our purchasing team advises us of sourcing changes?
That's a very good question, Bree. One of the things that we always talk about is that most companies, larger companies, are having their own team they establish, where they've got somebody from their purchasing department, somebody from their accounting, who usually sign the NAFTA certificates, that they get together maybe on a monthly basis and they sit down and they say what's happening in our area. Good example that you're probably talking about is you may have somebody in your finance, your CFO, for instance, may be signing the NAFTA certificate, aware of all of the rules. We had a situation with a particular company where their owners had challenged their purchasing people to save money on some of their inputs and to start looking at other countries. Most of the stuff they were buying were from North American suppliers. So what had happened was they really didn't communicate that back to the people that are doing the documents or signing the NAFTA certificate. So in the particular situation there, the particular rule for their product took a regional value content, and although they still passed the audit when they had one from U.S. Customs, what they thought was, you know, a requirement of 80% turned out to be 60. So it forced them to say, what do we need to do to be compliant? And there's some interesting white papers that we have on our website that we can send to you that that Reynold Martins has done and communicated, and it talks about the integrated trades strategies, and that people need to have their whole organization involved somewhat in those types of things. Does that kind of answer a little bit what you're looking for, Bree?
I'll see if she provides it all. We've got a question from our very own Brent, who's one of our sales representatives. He's asking ultimately who is on the hook if the vendor's information is wrong. Sorry, I'm sorry. I don't think the audience could hear me there. Again, we have a question from one of our very own, Brent, who is one of our sales representatives. He's asking ultimately who is on the hook if the vendor's information is wrong, using the corn dog example.
Well, interesting. At the end of the day, it's the importer that is responsible for any additional duties or penalties. Hopefully, you've got safeguards on your purchase orders that indicate to your supplier that should information provided be proven to be wrong, you're on the hook for any additional duties or penalties. Where that would go in a court of law is interesting. In the case of the particular corn dogs, I think this case could still be pending, but the reality is, from a customs perspective, is we're getting the duties and the penalties, if any, from you. So you've got to have those safeguards measures built in with your suppliers. And I know that we've always talked to our clients when they're, getting their NAFTA certificates to have some type of indemnification on their NAFTA certificate to hopefully protect them should these types of situations happen.
All right. Thank you, Bob. Well, it looks like that's all we have in our chat question line here. So I just want to finish up saying thank you very much, Bob, for that incredibly educational discussion. And thank you all for attending today's GHY University webinar. If you'd like more information or clarity regarding the free trade agreements, please contact Bob at the address bob@ghy.com, and feel free to connect with GHY International online via Facebook, LinkedIn, and or Twitter. So to reiterate, we will be sending out a copy of today's presentation slide deck, the recording of this webinar, along with a survey regarding your experience. Again, these surveys are very important for us to know how we are doing, and it would be greatly appreciated if you take 5 minutes or so needed to fill it out for us. And so thank you again for attending today, and please look for upcoming webinars on our website, ghy.com, or under events. Or if you are not signed up for our mailing list, you can email myself at maria@ghy.com. That's MARIA. And we hope that you all have a great day.